Now, I've been reading our comments already, and a lot of our viewers have quite the opinion on the trial of Kyle Rittenhouse. So let's talk about it. He is the teenager, in case you don't know, who shot 3 people, killing 2 of them during a night of protests in Kenosha, Wisconsin last summer. Now, the jury is deliberating his fate today. Here are some of the closing arguments made by the prosecution and the defense yesterday. I want you guys to take a listen.
And one of the things to keep in mind is that when the defendant provokes the incident, he loses the right to self-defense. You cannot claim self-defense against a danger you create. That's critical right here.
Kyle Rittenhouse shot Mr. Rosenbaum because he was attacking Kyle. Every person who was shot was attacking Kyle. One with a skateboard, one with his hands, one with his feet, one with a gun.
So something shocking happened in the district attorney's closing arguments. He pointed an AR-15, you see right there, near the jury with his finger on the trigger. A lot of people online, including some of our viewers, thought this was a bad call. So the judge also, this is another thing that a lot of you are talking about, the judge moved to dismiss the charge of possession of a dangerous weapon by a minor, saying that it was unclear whether that rifle qualified under the law. Of course, we all have our opinions, but I think what's really important is to hear from a legal expert. So we are joined by former prosecutor, veteran trial attorney, and of course, friend of the show, Mark Eiglarsh.
Mark, what's up, man?
Hey, Mark, great to see you.
Great to see you guys.
Okay, so let's start with the closing arguments yesterday. How do you think the prosecution and the defense did in this case, in your legal opinion?
They both did well. They argued their strongest positions. The prosecutor's position is you don't avail yourself of self-defense when you provoked the attacks. You did it. You went to that city. You went there with a gun that you weren't supposed to have. You claimed you were an EMT when you weren't. You put yourself in a very dangerous situation, and the way that you moved that gun around provoked others, and it was reasonably foreseeable. The defense, on the other hand, said, okay, when he was there, he was attacked. And when he was attacked, he reasonably feared death or great bodily harm, and he did what he was allowed to do under the law. Not guilty.
Wow, that's a really good wrap-up. All right, let's talk about the judge for a minute, Mark, because I am all over this Judge Schroeder. A lot of people are saying, sorry, Jeff, he has the same last name, no relation, saying he has not been fair with some of his decisions. I certainly feel like it's been a biased bench. What's your take on this, Mark?
I think he's doing the best that he can at his level of awareness. That's the nicest thing I can say.
Yeah, right. Very
he's
tactful.
Unusual. Nobody tells him what to do. I don't disagree with the type of tongue lashing he gave to the prosecutor, who did things that you should know better.
Yeah.
I knew as a prosecutor never to comment on a defendant's right to remain silent. I also know, having practiced for 30 years, that when a judge rules pre-trial that something should not come into evidence, you don't ever introduce it into evidence in violation of a court order. If anything, you go sidebar and you say, Judge, I'd like you to revisit your opinion because now the door's been opened. This is why I think I should be able to get it in. That prosecutor deserved every single thing that he got.
Hey, Mark, really quickly, sorry, Jeff, I just got to push back. Obviously, no legal expertise here, but I want to know your opinion. The fact that the judge did not allow all the evidence, right, to be heard to the jury. For instance, Kyle Rittenhouse, that video of him punching a girl. Kyle Rittenhouse, videos of him holding up a rifle, things that he said prior to the protest that could have substantiated, in my opinion, some sort of history or motivation. Do you think that that judge should have let the jury see everything? Why was he picking and choosing what the jury gets to see? That comes off bias, in my opinion.
Okay, and I appreciate that. And to people who don't practice in the criminal arena, that's a fair statement. But that judge did exactly what judges do every day. They don't let everything in. It doesn't come in. Samantha, God forbid you or someone you know is being prosecuted and they brought in every single thing they ever did wrong in their lives. It's not legally relevant. So this judge made certain findings where he balanced the benefit or the probative effect versus the prejudicial effect, the reason why it shouldn't come in. And he did a balance and he let certain things in and not. That's what judges do.
Thank you, Mark. So glad you're here. I want to talk about just brass tacks. What do you think the jury will ultimately decide? And a little personal question, do you think nowadays social pressure has anything to do with the jury's decision? Even if they think this person is not guilty within a reasonable doubt, being afraid on the outside that they might be accused of being a racist or a white supremacist by letting this person go, or vice versa. Is there any outside social pressure when it comes to the jury nowadays?
I'll start with part two. Of course there is. They're not robots. They are human beings. And even when the judge tells them, don't let sympathy affect your vote, don't let what you're seeing out there in the media, they're robots. They know that there are people out there counting on them to make a certain decision in one way. That said, most jurors get it right. They apply the law to the facts and they make a legal decision. And in this case, to answer the first part of your question, I expect them to say that he reasonably feared death or great bodily harm at the time that he pulled the trigger. And in case you're wondering, put yourself in that position or put a loved one in that position. Would you be outraged that they pulled the trigger under similar circumstances? The answer is no, if you're being intellectually honest.
All right. Well, Mark, I'm actually that's going to make me kind of change the question I'm supposed to ask, and I'm going to ask you this. We talk about precedent a lot of times with the law. We also know that we're in a time where there's a lot of political uprising, and there's people that protest quite often. If Kyle is found guilty, will that set precedent that now other people can then go to protests armed and then say, if they do discharge their firearm, I felt scared, and then kind of fall under a safety net of Kyle's law?
If he's found innocent.
If he's found innocent,
Yes.
setting that precedent.
This is not precedent. These facts are extremely unique to him and this case, as are every set of facts. The law has always allowed people to legally carry weapons, much to my dismay, because this is a killing machine that he had in his hands, and I don't think he should have had one, and my kids would never have something like that. But that said, it's their legal right to do so. But this doesn't set precedent. The law always allowed people to be in places with a gun as long as...
Oh no, I hope we didn't lose Mark. Okay, so hopefully we're going to get Mark back. What I wanted to ask Mark...
He answered a lot, though.
Very good
I know.
Really good.
It's
Man.
so important to hear that. But that's where I feel this disconnect, right? And I get it. We have to have, Tori can answer this better than anybody, really strict protocol when you come to the court of law. I understand that. But at the same time, if I were one of those protesters, let's say he skateboarded there, okay? And this is just a hypothesis. If I saw Kyle Rittenhouse approaching me with his gun, I would automatically, because of the climate we live in, I would think that's not a police officer. That fits the bill of a mass shooter. That's what I would think. Oh, we have Mark back. Mark, can you hear us? So what I was telling the panel is my fear. Let's say I am at a protest, which I've gone to many protests before, okay? And let's say I have something in my hand that could be used as a weapon. If I saw someone approach me with an AR-15 that looked like a 17-year-old, I'm going to deduce in my mind that's not a cop. That looks like a mass shooter. I might then try to defend my life. So I understand that we hear the fact that Kyle Rittenhouse may have felt like he was defending his life, but what about the two people who can't defend themselves that may have been defending their lives?
You make an excellent point. And add to that the person holding that weapon of destruction is a 17-year-old whose frontal lobe of his brain, the portion governing reasoning and judgment, hasn't even been fully formed. That's a kid I'm more afraid of than an adult with that type of weapon. That said, as long as he's legally allowed to own one, and quite frankly, he wasn't when he was 17, but now he is, he can walk around in certain states and do that.
Tori?
It's frightening,
Mark,
but it
is
a necessary evil.
Real quick, what do you think about the judge's ruling to take out the charge of the weapon charge due to the 1-inch length difference in the gun? Do you think that was a good call? That was a 9-month sentence if he was found guilty.
Yeah, the judge had to do it. He didn't do it on his own. It was done at the direction or request of the defense, who said that the prosecution didn't prove that legally it was the size it was supposed to be. That was an easy call. Don't blame the judge for that one.
Wow. Well, you are always, you're always here to clarify.
Great stuff.
I will never
Yeah.
understand the law, but thank you, Mark, for trying to put it in layman's terms for us. We appreciate you. For more information on Mark and his law firm, go to speaktomark.com. We'll be right back.
Man
Thank
knows
you,
what
Mark.
he's talking about.
Mark.
Appreciate you, man.
Thank you.